Seconds to go. Start. Section 173(6) of the Code permits the police officer not to furnish statements or make disclosures to the accused when it is inexpedient in public interest. In such an event, the police officer is to indicate the specific part of the statement and append a note requesting the magistrate to exclude that part from the copy given to the accused. He has to state the reasons for making such request. The same principle will apply. We now turn to the scope and ambit of judicial review to be exercised by the court. Judicial review does not amount to a mini trial or a merit review. The exercise is confined to ascertain whether the reasons to believe are based upon material which establish that the arrestee is guilty of an offence under the PML Act. The exercise is to ensure that the DOE has acted in accordance with the law. The courts scrutinize the validity of the arrest in exercise of power of judicial review. If adequate and due care is taken by the DOE to ensure that the reasons to believe justify the arrest in terms of Section 19(1) of the PML Act, the exercise of power of judicial review would not be a cause of concern. Doubts will only arise when the reasons recorded by the authority are not clear and lucid, and therefore a deeper and in-depth scrutiny is required. Arrest, after all, cannot be made arbitrarily and on the whims and fancies of the authorities. It is to be made on the basis of the valid reasons to believe, meeting the parameters prescribed by the law. In fact, not to undertake judicial scrutiny when justified and necessary would be an abdication and failure of constitutional and statutory duty placed on the court to ensure that the fundamental right to life and liberty is not violated. At this stage, we must consider the arguments presented by the DOE, which rely on judgments regarding the scope of judicial interference in investigations, including the power of arrest. Reference in this regard was made to the King Emperor versus Assistant Director Enforcement Directorate FERA. In our opinion, these decisions do not apply to the present controversy, as the power of arrest in this case is governed by Section 19(1) of the PML Act. These decisions restrict the courts from interfering with the statutory right of the police to investigate, provided that no legal provisions are violated. Investigation and crime detection vests in the authorities by statute, albeit those powers differ from the court's authority to adjudicate and determine whether an arrest complies with constitutional and statutory provisions. As indicated above, the power to arrest without a warrant for cognizable offences is exercised by the police officer in terms of Section 41 of the Code. Arrest under Section 41 can be made on the grounds mentioned in clauses A to I of Section 41(1) of the Code, which include a reasonable compliant, credible information or reasonable suspicion that a person has committed an offence or the arrest is necessary for proper investigation of the offence, etc. The grounds mentioned in Section 41 are different from the juridical preconditions for exercise of power of arrest under Section 19(1) of the PML Act. Stop.